In my most recent blog, I spoke about the effectiveness of mediation as a tool to resolve a personal injury case. Indeed, mediations are bringing about a lot of settlements and avoid further litigation, even a trial. I have become an advocate of mediation. But what makes for a good mediation? What is my perspective as an attorney for people who have been injured as to what I will do in a mediation and as to the course of that mediation? Let me say about what I will do as the advocate in the mediation. I will make a presentation in the first 20 minutes of the mediation setting, and I will put my case forward as best as possible. As I said in the last blog, we have to address both liability, if it's contested, and damages. What is the best way to convey that? What is the best way to show that? And I'm reminded of what is said about real estate. It all is about location, location, location. In a mediation, as in a trial, it's all about preparation, preparation, preparation. A mediation is not as formal as a trial. There are no rules of evidence. But it would be foolhardy to come in as if you were doing something that's casual or unimportant. Indeed, it's extremely important because it will bring about, hopefully, the conclusion of the case and a satisfactory degree of compensation for someone's injury. Kind of preparation I do is a thorough understanding of the law, a thorough understanding of the facts, and finally, an effective, perhaps graphic portrayal of the injuries. By graphic, I don't mean things that are, shock the conscience, but I would come in with demonstrative evidence, pictures of x-rays, pictures of scarring, for example, and things of that nature. There should be a demonstrative evidence portion to the mediation, just as you would want it to be for a trial. There is no difference in terms of the amount of work, even if the rules of evidence do not apply in a mediation. I have also said that after the presentation by both parties, the mediator separates the parties so that I would go into a separate room with my client or clients, and the mediator will do that shuttling back and forth. I also find it important to have a sense of what will happen with the liens. Liens are very prevalent. They could be money owed to Medicare or private health insurer, or they could be money owed to the workers' comp insurer if this is what is called a third-party action and there has been workers' compensation payments. Obviously, those figures are important to know because that will let you know what is put in your client's pocket if a settlement is reached. And I approach the mediation once we're separated that not necessarily do we have to come to settle the case. We will go in good faith, but we will still strive to get 100 cents on the dollar as the client is entitled. Thank you.